Hey guys, Balak Hassan from Pacific Workers. I get a lot of questions about when workers' comp doesn't necessarily cover a work injury, and so I thought today we'd do an episode on the exceptions to workers' comp that are set forth in the Labor Code. So if you're not already familiar with it, you'll want to check out Labor Code Section 3600, that's 3600, and ultimately that is the code section of the Labor Code that sets forth when a workers' comp injury is not covered. And so if you look at that statute, you see that there's a couple reasons why a workers' comp case could be barred. The first one being that the injured worker's injury was actually caused by voluntary intoxication. That means if the person happened to be drunk or they were on drugs, and it was the fact that they were drunk or on drugs that actually caused the injury, they wouldn't be able to collect benefits. Now, it doesn't mean you can't be drunk or on drugs and still get injured and still collect workers' comp. The defense has to prove that the intoxication itself actually caused the injury, meaning that you were so drunk you couldn't drive, or you were so drunk you couldn't balance and you fell off the side of scaffolding, something to that effect. So it's a very nuanced issue, but that's one of them. The next one is where the injury is not intentionally self-inflicted. Of course, this means that you can't purposely saw your arm off or purposely throw yourself down a ladder or electrocute yourself. It has to be an accident. So you definitely can't get hurt intentionally in order to collect workers' comp benefits. The next one is whether you're fighting. You can't mutually engage in combat and engage in violence and then turn around and collect workers' comp benefits for it. So if you initiate a fight, you would be barred. However, if you are in a fight and you're at work and you have to defend yourself, that is not a bar. So for example, I had represented a client and they were shot by someone that was assaulting them. And even though they were fighting back, it wasn't a bar to their case. They had the right to defend themselves in those circumstances. So just be aware of that as well. The next one is if they are actually committing a crime, like a felony. So if you're, during the course of your work, rob your employer and you get injured, you probably won't be able to collect benefits from that either. One of the other big ones is voluntary participation in a recreational activity, which is actually a hot topic. Oftentimes, people engage in extracurricular activities for their work, whether it's driving to a picnic or an off-site company event somewhere else, and they get hurt. And it's a question of whether or not that event is considered a recreational activity for purposes of workers' comp. And the answer to that is it really depends on the situation. Every case is different. So that's it for today, guys. If you have any questions, please feel free to follow up with us. www.pacificworkers.com.